Good morning, good afternoon, good evening, wherever you are in the world. Uh, New things coming up. Today is Friday, May 22nd, 2026. Yesterday, we had this policy memo come in by the US Department of Homeland Security, and it's 8 to 9 page document which I have in front of me, and we are going to decipher this and the effect that this would happen or is expected to happen on all folks. And the reason I'm making this video is for all those people who are our clients, who are not our clients, who are just out there waiting for their adjustment of status. At least they should know what to expect, and more importantly, how to be ready, how to be prepared for that. So, getting on the analysis, first of all, what they're saying is this is the end, the third part towards the green card. तो उसका जो the initial part is you already have an I-130 approved, you already have an I-140 or a labor cert approved, and then you go to the final step of getting the green card. This green card that you get is through either adjustment of status, which is in the US, or a consular processing, which is outside the US. So what the government is saying is that as a matter of right, sorry about that, as a matter of discretion, they are going to treat the adjustment of status. Whereas, as a matter of right, it is you go out and you apply for your green card outside the US. So, this policy memo is primarily making a big difference, saying that for all green card purposes, you remain wherever you are outside the US. And you go for your green card interview. Once you get your green card, then come into the US. So what this policy memo is now defining is, since there was an alternative which still exists, the adjustment of status, we are going to deal with it more strictly. That adjustment of status is going to be with much more questions, background checks, information on what the person has been doing on his or her non-immigrant status, and what was the intention of the person when the person came to the US and initially did whatever he was doing. So the first thing they're saying is, again, they are reiterating this all throughout this memo again and again. This adjustment is a matter of grace, it is not a matter of right. And again, what they're saying is that this has to be taken with the utmost caution and with a view towards the national interest, giving more discretion to the officers. They are discouraging this process, the adjustment of status, rather encouraging the consular processing. Now, we all know anytime you go outside the US, you're doing a consular processing, it can be tedious. It can have more repercussions. You have to stay outside the US. You discontinue your whatever ties you have in the US. So it's going to be more cumbersome. And what they're saying is that the adjudicator must balance the adverse factors evidencing an alien's undesirability as a permanent resident with the social and humane considerations presented on his behalf to determine whether, again, the grant of relief in the exercise of discretion. So that time and again, what they're saying is this I-485 is a discretion. It's not a matter of right. One of the things which they are giving benefit of is saying that whenever a USCIS officer makes this determination on the green card, it's immediate. Whereas in the consular processing, it still goes through a certain set of other facts, which makes it a bit longer for the person outside the US to get the green card, whereas in the US, it's much more quicker. So they're making things more difficult. What they are saying is that in this particular memo as well, and that's the good part, they are not outlining certain factors and saying this is what you have to follow. What they're doing is, at the end of the day, it's the officer who's going to make this determination on a case by case basis. So the facts, the circumstances of each and every case are to be looked into. And based on that, the officer is going to make a determination as to whether the green card is warranted or not. So, What they're saying is that they're going back to the statutory scheme of the green card. And they're saying that even over there, Congress expects that folks would go out and apply for the consular processing instead of the adjustment of status. So that's what they're saying they should do. Not commonly rely on the adjustment of status. Uh, what they're asking the officers are to look at each and every violation. Now, those violations could be that a person came to the US, let's say on an F1 student visa, was supposed to go to school, for some reason was not able to attend school, and the F1 status was terminated. But later on, filed an application and the F1 was reinstated. They're going to look into that as well. The person had an argument somewhere outside, went into a fight, was charged, but then later on dropped with assault or battery or anything of that sort, or maybe uh, even something which is within families. Uh, but they are going to look into each and every factor. If a person worked without authorization, which is very common, people need to survive and they find means to make money, uh, that can be something. One of the common factors that we come across is people who are physically in the US and what they say is, I'm doing remote job. I'm working for a company outside the US and they are paying me. Even that can be considered. Applying for any public benefits. Another example would be a person who is on an H1B and is required to work for company A. Well, he is not working, he or she is not working for company A, instead working elsewhere. E2, a person is required to invest and be in his or her own business, and he or she is not doing that, has an investment but is working elsewhere. So things like these, they are going to look into it. It's going to be the totality of circumstances and overall assessment. So now we have to be more careful. That means each and everything that is being done is going to be closely monitored. We have to be mindful that each and everything will be taken by the officer, and then a final determination has to be made. Because I think so, what happened was that the current administration thought that, you know what, we're going to uh, revoke the green cards of folks coming into the US, or finding reasons that we're going to find one or the other fault and then revoke the already approved green cards. So this way, they're going one step even back. They're saying, why not even let them get the green cards in the US? Leave it altogether. So that's something which they are doing. And we have to be even mindful of that. One other thing which they are mentioning over here is that an alien's failure to comply with the conditions of their non immigrant admission and the alien's failure to depart are highly relevant to the analysis of the officer when making the adjustment of status case. So they are going to look at, why did you come to the US? What was your intention at that time? Way back to when the DS 160 was filed. What was mentioned in the DS 160? Did you mention that, yes, I'm going to go back, or mention that, no, I will just come temporarily, and then you change your mind? So all these things are going to play a role. What they do mention is that the adjudicators must weigh all the positive and the negative factors. So everything has to be done in overall. The one thing which always is sort of taken with the benefit that it comes is the reasons which are mentioned in the denial. So here is the interesting part. The approval always is a one-page document which says, congratulations, your case is approved. However, on the denial, what they do is they have to make a detailed determination. They do mention denial reasons, the totality of the circumstances, what were the things in your favor, what were the things against you, and then make that determination. So it's all the more important that you should have a complete history of what all you have been doing, a history of what things were expected from you, what you did do, so that whenever it comes to the overall analysis, you should be able to show that you have never violated the terms and conditions of your visa. You have stayed in status, because at the end of the day, it is your life. You have to be in control. You have to be knowledgeable about it, regardless of the fact how many attorneys, law firms, paralegals, or different people come and go and they work on your case. Uh, these are tiring times. We are with each and every one of our client. Due diligence is like never before. And so that's why even more time and diligence is required in each and every step that we take. Uh, I would request each and every one of you as well, be mindful and best of luck. Let us know if you need any of our assistance and would be glad to help. Bye for now.